Good afternoon, everyone. My name is Whitney O'Reilly. I help run our wealth preservation department here at Cohen Seglius. We're a large construction litigation firm, but we also have transactional work, labor and employment work, and of course, wealth and preservation department. So I'll chit chat with you all a little bit to make sure we get enough people on this call before we get started. But what we're going to talk about is estate planning 101 today. What are the 5 most important clauses for my will or trust? Maybe you have your will or your trust out and sitting in front of you. You can sort of check off on a piece of paper. I have these things and I've thought about these things, or I'm going to circle back with my estate planning attorney to see if it really is the right clause and it fits in my plan. But a little bit about me for anybody who hasn't been on this webinar before. If you have been here before, thanks for coming along again. It's just a quick 30-minute lunch and learn. So it doesn't take too much time out of your day and you get a little bit of wisdom, at least in the estate world. I have been practicing estate planning, estate administration, and trust work for about a decade now. So I have a wealth of information when it comes to wealth preservation. And I know I have a lot of people say to me, you know what, why would I spend the money going to an attorney to draft an estate plan, to take care of these things? What do I care? I'm going to be dead. And the answer is you do care. We all care. When I pass away, I don't want my children to fight over my orange tree that's in my house. That's really important to me and maybe important to both of them so that they never speak to each other again. If something were to happen to me right now and I have young children, I'd want to make sure that there were provisions under my document that took care of my children and the assets that I'm leaving to them. So all of these things are really important to all of us. So what I'm going to do, and I know this is only a quick 30 minutes, so I'm going to dive right into the information. But what I'm going to do now that I see most of the participants on now is I'm going to send out a poll. Now, this is the first time I've done this, but who on this webinar has a will or a trust in place? Do you actually have one, or are you on this webinar because you don't have that yet? So you can answer the question yes or no, and let's see if we've got a bunch that already have wills or don't have wills. So let's see, and I'm even gonna, oh, it doesn't let me click it. Well, I'll let you know. I have a last will and testament. Every about 5 to 7 years, I update that document. Sometimes I update it sooner. When I had my second child, I updated it again. When the laws changed pretty recently, I updated the document again. So this is a living, breathing document, your last will and testament or your revocable trust. It has to account for all the changes in the laws, all the changes in your life. So it's living in the fact that it every once in a while has to be revisited. Okay, and it looks like 64% of you on this webinar have a will or trust, and 36% of you don't have anything. Oh, that scares me a little bit. So I'm so glad you're on this webinar. I'm so glad you're thinking about an estate plan and why you need that. So let's get started on when you do get an estate plan and you do have a last will and testament or a revocable trust, or for those other people who already have that plan in place. Does it really have the clauses that it should, and does it need to be updated? So the first most important clause that we're going to talk about, they're not in any preferential order. I just think these are the 5 most important. Of course, I think there's millions of important clauses, but these are really important and should be in each and every one of yours, last will and testament or revocable trust. And I'm going to stop for a second because I'm going to keep using will, but some people have a revocable trust instead of a will. I've certainly done webinars on wills versus revocable trusts. I will certainly do more in the future. And if you have a question about whether or not you should have a will or a revocable trust, certainly reach out to your estate planning attorney. But we're going to use will for this webinar, but they mean the same thing. So the first thing that we want under our will, revocable trust, is we want this personality clause. And so this isn't a typo. This isn't personality, and I've just mistyped it. This is personality. That means the things that are inside your house. This is one of the biggest things that people litigate or people fight over is stuff that's inside your house. So for one example, we've got my orange tree. I'm very into horticulture. I have lots of plants inside and outside of my house, and they mean a great deal to me. Let's see if I can move this camera a little and you can see a picture on my wall. So let's say he's a famous artist, and he actually is. His name is Morris Katz, and he's the world's fastest painter. Who gets that picture? Who gets that orange tree? And does it matter? So we can do a lot of different things with the things that we have when we pass away. We can put them in our last will and testament as a specific bequest, as in, I give my orange tree to my son Paolo. I could also simply put, and I'm going to change to the next slide to show you this. I'm showing you something from my last will and testament, which is my memorandum, which says there might be special things that I have that I want to give to specific people, but I don't need it to be a specific bequest. I just want to give the executor or the trustee a little bit of direction on where I want things to go. So this is a great place to put things like an orange tree. This would not be a great place to put a Picasso picture. If it's something that has great intrinsic or great value, monetary value, we might want to put that in as a specific bequest in the will. But this is a great place if you have a will. Check and see if you have a memo in the back. Make sure you have that personality clause that says what happens with your things and who gets them. And something else really important about this personality clause is who pays the tax on these items? What if something is damaged or destroyed? Who gets the insurance proceeds? Who has to pay for shipping? So this comes right out of a piece of litigation that I worked on years ago, which is a whole dining room set was going to one of the beneficiaries in California. It was going to cost many thousands of dollars to ship it. And the rest of the children thought that there should be an equalization in the residuary so that everybody still received an equal amount. Well, the beneficiary receiving those specific personality items thought that it should be paid out of the estate and the rest should be divided. So you can see really easily how all of a sudden it could be something of a contention point, as in, did mom mean for it to get shipped and paid for out of the estate and then everything else equalized? Or did mom mean if you take this dining room set and it costs $1,000 to move it, that $1,000 comes out of your share? I don't know. If we don't put it in your last will and testament, we don't know. And when we don't know the answer to something, that's when things are litigated. When there is ambiguity or there's nothing related to that particular topic inside your will or trust, or let's say for the 36% of people on this call, you don't have a document at all. So now you're down to the default laws of whatever state you happen to be in. Right now, I'm sitting in Chester County in Pennsylvania. So the Pennsylvania default law, if I were to pass away, is some of it goes to my husband, but a chunk of it goes down to my children as well. And that's actually not what I'd want to have happen. So it's really important that I have a last will and testament. And of course, we have to think about the sentimentality. What do I want done with my wedding ring? If I have a necklace that came from my great-great-grandmother, where would I want that to go? And would it be helpful to specifically say it ahead of time so that the family knows that these are really my wishes? Again, who decides this? If we put it in your last will and testament, who's making the decision on where all these things go and to whom? Are we giving that role to the executor? Is that a different person? Do we have this memorandum so that we're giving whoever it is we've appointed to dole out your personal things? Have we given them some background information on the things that are important and where you want them to go? I know for me, one of those things that you use on a memorandum is an animal. What if you have a dog or a cat and you want it to go to a neighbor or a friend or someone like that? This is a great place to put that information. So the first most important clause that you should have is a personality clause. Very simple, just talks about the things that you have inside your house: tables, chairs, jewelry, clothing. But It can be a bit more complicated than that, as in, we want to make sure we understand who pays the tax, who pays the insurance, who pays the shipping, who makes the decision on where these things get to go, and how much information do you want to give that particular person. So the second most important clause is a spousal trust. So there's lots of different kinds of trusts that you can have inside your last will and testament or your revocable trust. And so this is really important. If you don't have a trust for your surviving spouse, you probably should. Whether it's just a credit shelter trust, whether it's a disclaimer trust, whether it's some other kind of marital trust like a Q-tip trust, which is a qualified terminable interest property trust. These are all different ways that we can get money to a surviving spouse and take those assets in a tax beneficial way and at the same time get incredible creditor protections. So we're moving assets to the surviving spouse in a better way possibly than it going outright. So one of the things that I will say is if you have a last will and testament or revocable trust that's before 2012, you could have spousal trust in your documents, but they're actually probably the wrong kind of trust. So before we had to do these very complicated A/B trusts where we had multiple kinds of spousal trusts in your will, and it dealt with the exemption levels for federal estate tax purposes, how much got funded into each trust. These days, for many families who are under the exemption amount, and so let me stop for a second and tell you there are two taxes you have to worry about when you pass away, at least for Pennsylvania purposes, the Pennsylvania inheritance tax. That tax is 0% between spouses. Anything that goes down to children is taxed at a 4.5% tax. Anything that goes to your brother or your sister is taxed at a 12% tax. And anything that goes to anyone else, like a friend, is taxed at 15%. There's also the second one, the federal estate tax. Right now, I have an $11.7 million exemption from that federal estate tax, and so does my husband. And today we have something called portability, where we actually don't need a trust in place in order to take my exemption when I pass away and stick it on top of my husband. So in effect, we can get double that amount of exemption when assets travel down to our children, which is really important because the federal estate tax is a 40% tax. And you might say again, well, I'm dead, what does it matter? And the answer is I'd prefer 40% more to go down to my children, my grandchildren, my family members than, let's say, the federal government. So it's really important to have a spousal trust. Which kind of a trust really depends on the assets that you hold, the situation that you're in. For many of my clients, a disclaimer trust is a wonderful vehicle where we have an optional trust in place where you can decide now or in the future whether or not you'd like to fund that trust. So it adds a bit of flexibility that we didn't have many, many years ago. When we have multiple marriages, a lot of times we have Q-tip trusts so that allow the surviving spouse a lot of the ability to get funds from that trust, but at the same time we're sort of safeguarding those funds for, let's say, your children from a previous marriage. So again, personal property clause, really, really important. Having some kind of a spousal trust, really important. If it's before 2012, you might have the wrong trust. After 2012, just make sure you've got something in place so that we can get as much as we possibly can to our surviving spouse in the best possible way. So now we're going to talk about the third most important clause in your last will and testament, and that's the minor's trust. What do I do if something happens to my husband or I and we have children? My son just turned 9 and I have a 14-year-old daughter. If we were to pass away, I would not want assets to go outright to my children when they turned 18 or 21. So how do I make sure that they don't have $1 million sitting in a bank account when they turn 18 to make all the mistakes that they're probably bound to make? And you might say, well, my children wouldn't make those mistakes. I can say I've been doing this for a decade, and there's very few circumstances where minor children in their late teens or early 20s make great decisions with large amounts of money following a tragic situation like parents or a parent passing away. So we have children, let's set things up in the way that they should be set up so that we can make sure that they get the best use of these funds in the best possible way. But what does that minor's trust mean? When should that trust go to? Should it go outright to them at some point? Maybe when they turn 30 or 35. Maybe it should stay in trust their whole lifetime for asset protection, marital protection, spendthrift protection. Maybe I shouldn't even have a minor's trust. Maybe I should just have a minor's provision that at least extends the age of majority to 25, which is a pretty recent piece of legislation here in Pennsylvania, that a minor can be considered a minor till they're 25. And of course, minor is a funny word because in lots of different states and lots of different contexts, that age is very, very different. So it's important to keep a minor for as long as possible so that they get as many provisions that Pennsylvania or whatever state you're in allows, so that your children gets as many benefits as humanly possible from those laws. Again, think about when that money should go outright to them, if at all. How about a distribution standard? When should they get money from this trust? Should they get money for anything they want? Should they get money only for education? Should they get money only for support and maintenance? What are the things that are important to you if you weren't here anymore for your children? And then, of course, who would we want in charge of that trust? And this goes along a little bit. I didn't put the guardianship clause as the 5 most important clauses, but I will say for anyone on this call who has children, or if you're listening to it for your child who has a child, to make sure they have that guardianship provision. This is 2 separate provisions. So the guardianship provision is going to say who has physical custody of your child, whereas this minor's trust is who takes care of the financial stuff that's going to your children. And oftentimes we don't want them to be the same person, so that we have some form of checks and balances. So again, personality, really important that we've got that clause in there. Who pays for what, and can we give some guidance to whoever's in charge of it? A spousal trust, really important to have a trust in place for the surviving spouse. Depending on what kind it is, depends on your particular situation. If we have minor children, and this isn't even for people who have minor children like me, it's also for people who are giving things to their family members in a persterpital distribution. So you'll look through your will and your trust and you'll see if you see that. And what that means is if one of your children passes away, you're going to give things to a grandchild or great-grandchild. It means by the bloodline or by the branch, it goes down through your family line. So you'd want this provision in your document, even if your children are older than the age of 25 or 30 or 35, because if anyone inherits under that age, we want to make sure that we have protections in place to safeguard that child and these funds to be used for their care for their lifetime. So the next clause is the tax clause. This is a really big, bad one. And this morning, when I was answering my emails, it's funny, I'm on a chain of emails with a bunch of tax attorneys here in Pennsylvania. And this was one of the questions that was asked earlier today by attorneys that do this for a living. Here's this clause. What do you other attorneys think that means? So this is a very, very complicated piece of drafting your estate plan. And what I'd say to this is a lot of people say, isn't some of these things boilerplate? You just take a tax clause and you throw it into the will and it looks just like the other person's. And the answer is maybe, but maybe not. Very specific words mean very specific things that aren't necessarily intuitive to a lay person or even to fellow attorneys. We really have to make sure that the clause says what we want it to say. And so make sure, this is number 4, that you have a tax clause. And then what that tax clause says is determined by what you and the attorney come up with. And so what I mean by that is, who do you want to pay the tax? Here in Pennsylvania, in New Jersey, in Maryland, there's lots of states. In New York, there are lots of states that have a tax. And even if not, the federal estate tax, all states are subject to that federal estate tax. Who do we want to pay that tax? Do we want it coming out of our estate and the rest going down to our beneficiaries free of tax? Do we want each individual beneficiary to pay their own tax? Well, it depends on the situation. It also depends on who those people are. Because if you remember me saying earlier, the taxes, for at least for Pennsylvania purposes, are different for different classes of people. Another thing to think about, we talked about the personality clause. What if we have a specific bequest of a thing? Who do we want to pay tax on that thing? Do we want it to be that person? Do we want it to just be your residue? What do we do about jointly owned property? I own a piece of real estate, some farmland with my sister. When I pass away, if it has a right of survivorship, it goes to her. Does my will speak to jointly owned property? Do I know if my estate is paying that tax or my sister is paying that tax? What if that piece of real estate is bigger than any other asset that I have? Does it make sense to have the tax paid from one spot or another? So it's really important to have that tax clause and to understand what that tax clause means. So the last one that we're going to talk about, we have about 10 minutes left. Wow, this speeds along so fast. The fifth one, we've got personality. Make sure we've got a clause about the stuff that we want to give away and who we want it to go to. Then we want a spousal trust inside your estate plan. We want a minor's trust or something for minors. We even want to think about that guardianship provision. We've got a tax clause, really important to have a tax clause. And that tax clause really has to speak to all of the specific situations going on in your asset scheme. And now we have the no contest clause. This is really important. We don't want your family members to fight over things. If I give 75% to my daughter and I give 25% to my son, there's a reason that I'm doing that. And I don't want them to go to court to fight about it. I want there to be a clause in my document that says, this is the way that it goes. And if you fight about it, you get zero. You're disinherited, which means 100% goes over to the other child. I can't tell you how well this works to keep people from fighting with each other over the dead person's intentions so that we can smoothly conclude the estate administration. Keep family ties together, keep family unity. This is really important. Now, I will state not all states allow a no contest clause. It's also called an interim clause. Places like Florida. What I will say is, even when I draft documents, we draft documents in many states here in the United States. I still often put it in because I think it gives some sort of direction that this is really what your mom wanted. This is really what your dad wanted. Please don't fight about it. And we'd be surprised how often that works. Really important, who's included on that? Are we including a spouse in that no contest clause? Just children? Are we including trusts in that no contest clause? Lots of different considerations go into that no contest clause. So there we've got the 5 most important clauses that should be in your estate plan. And what is an estate plan? An estate plan includes your last will and testament or revocable trust, which says what happens to your things when you're not here anymore and who's in charge of them. But it also includes your financial power of attorney. That's the person who's going to help make financial decisions for you if you become incapacitated. I get COVID-19. I'm on a ventilator. Who continues to transact business for me? Who continues to pay my employees? That's my financial power of attorney. Medical power of attorney. I'm on that ventilator. Who's going to make medical decisions for me? Is it my spouse? Is it my daughter who's now a doctor? Is it a neighbor? Is it a friend? And then the living will. I want to give some direction to my family members. This is what I do or I don't want at the very end stage of my life. So, of course, if you're looking at your last will and testament or you're thinking about having a last will and testament or a revocable trust, just remember these all go together. They work together. So if someone's offering to do a last will and testament or revocable trust, ask them about a comprehensive estate plan because it's really important to have a will, but on top of the will, it's really important to have these other documents in place. So here I just wanted to show you, we're not going to have too much time to look at this, but this video will be up on the website. If you reach out to me, I can certainly send you these slides. This is just important. I get people say things like this all the time. Isn't there just a boilerplate tax clause and you just stick that in all the documents? And I say it's just unfortunately not that simple. And here's a situation. This came from the Philadelphia Bar Association. These are some cases that have come down through Pennsylvania over the years regarding tax clauses that often look very, very similar. And if you read them, you might say, oh, all taxes paid out of the residue, or oh, I think the beneficiary has to pay the tax. And you'll see that the court's answer either doesn't match what you think the answer should be, or you have to go back and read it again and say, oh, wait, does my tax clause talk about probate and non-probate assets? Does my tax clause talk about trusts? And the answer is we really need to make sure that the tax clause works with your entire estate plan and deals with all of your assets in the myriad of ways that you can hold assets. So give this a look when you get a chance. Really helpful. Make sure if you do have a tax clause in your last will and testament or revocable trust, if it says one of these things and it doesn't do what you think it should do, reach out to your estate attorney to get that fixed. That's a pretty constant problem that I see in estate administrations, is a tax clause that says all taxes are supposed to be paid from here and all assets going here. And there are two different sets of people. So we have a lot of problems with that. So it's really important. So we only have a couple of minutes left. For all of you on this call who, on this webinar, who know my webinars, I love trivia and I love to give away prizes. So on the next slide, I have a question for you. The first person who gets the right answer, and I'll have you put it in the Q&A. This is actually my first webinar by Zoom. I've been using a different platform before this. So hopefully nothing was glitchy for anyone, but Zoom is pretty user-friendly. So plop it in the Q&A, and afterwards you'll get an email with your prize. So here we go. So everybody who was only half listening and only knows that there's 3 important clauses, or remembered the last important clause. 1, remember now, personal property clause. Make sure you got a spousal trust. Make sure you have a minor's trust. Make sure you have a tax clause, and make sure you have a no contest clause. So here we go. I'm going to ask the question. The first to get the right answer wins a prize. So who pays the tax? My will has a tax clause. I have a will and it has a tax clause, and it says, I direct my executor to pay inheritance, transfer, estate, and similar taxes assessed or payable by reason of my death on any property of interest in property which is included in my estate for purpose of computing taxes. So I have an IRA with my daughter Patience named as the beneficiary. I've got lots of webinars on beneficiary designations. Always check your beneficiary designations. And my will says that everything that I have, my residue, goes to my husband, Brian. Who pays the tax on the IRA with this tax clause? Is it my daughter, Patience, who gets the IRA? Is it my husband coming from the residue, the assets that are going to my husband? And I'm looking at it, seems like we've got lots of answers. Let me just make sure I've got at least one right answer. I'm going to wait a few more minutes. And I would say, I normally say in the beginning, anytime you have a question, certainly let me know. I normally try to add in the answer as we're speaking. But if I don't, I normally get a list of questions and I'll reach out to you afterwards. But feel free to reach out to me at any time. And let's see, we've got, oh, and isn't this funny? We've got a bunch of people saying one and a bunch of people saying other. And so this is actually really important. Even if we don't know the answer, is it good that we have people saying it's the daughter and people saying the husband? Because we talked about earlier in this webinar, having ambiguity is where litigation comes in, is where families start fighting with each other. So we never want something that we're not quite sure who does what. So the answer here is actually the daughter. So it's A. And the reason that it's A is because it doesn't speak to probate and non-probate assets. So by adding one word, it could look very identical, but actually come from B, the husband. Now, I don't know, which way do we actually want it to go? So first we have to think about, does the tax clause actually say what we want it to say? But then if it is saying it that way, is that really who we want to bear the cost of the tax? So that's really important as well. Now it's 12:31, so I'm being told to hop off. I appreciate everyone being on this webinar with me. Again, I do these once a month. Certainly reach out anytime you have a specific thought for a webinar topic. Of course, reach out to me anytime you have a question. And I just appreciate you being here, because the fact that you're here means you're thinking about your estate plan. You're thinking about whether or not your plan needs to be updated. You're thinking about, do I really have the best plan in place for me, for my family, or should I have an estate plan? So again, I appreciate you listening to me. If you have any questions, or if I haven't answered your particular question on this Zoom, certainly reach out. I'll reach out to the winner. It's a $50 gift card. So join me next month to try it again, and have a great rest of your day. Have a wonderful day, everybody.